everybody, welcome to iExamBee's LegalBee. This is Amrita, your law faculty at iExamBee. Welcome to the daily mock test series that we have started exclusively at LegalBee, in which we will be discussing questions from various subjects and also topic wise. So अगर आपने बाकी के videos miss कर दिए हैं, go and check out the playlist and check all the videos that are available. These are very beneficial videos as these are practice questions. आप इन PPTs को download करके रख सकते हैं and later on also you can practice these MCQs. It can be a very good revision for you. अगर आपके कोई भी doubts हैं, you can reach out to us on hello@iexambee.com or in the comments section of this video. You can also call us on 920552408 if suppose you want some questions on any particular topic from any law, then also you can mention in the comment section. We will definitely try to come up with a video on that if we have already not covered that area. Other than this, I also wanted to give you an update about the UGC Net Law free mock tests that are available at iExamBee. These mock tests are very helpful and are free as well. अगर आप UGC Net Law examination के लिए prepare कर रहे हैं, that is going to be conducted on 16th of June, तो आप इस mock test को attempt करके exam ready बन सकते हैं. These two mock tests can help you a lot in understanding the direction of your preparation, your strengths, weaknesses, and it will help you understand that how you have to manage your time and whatnot. As you all know, strategic preparation is very, very important, and also you can understand the last minute tips in your preparation. Arbitration and Conciliation Act 1996 में स्टार्ट करने वाली हूँ आज के वीडियो में. बाकी के वीडियोस आप चेक कर सकते हैं. अलग अलग लॉज, अलग अलग टॉपिक्स हमने डिस्कस किए हुए हैं. प्रीवियस वीडियो में मैंने लॉ ऑफ टॉर्ट्स के इंपॉर्टेंट क्वेश्चंस कंप्लीट किए थे. एंड नाउ आई विल बी डिस्कसिंग आर्बिट्रेशन एंड कंसिलिएशन एक्ट, विच इज़ अनदर वेरी इंपॉर्टेंट टॉपिक एंड काफ़ी सारे कॉम्पिटिटिव एग्जामिनेशंस में इसमें से क्वेश्चंस भी पूछे जाते हैं. आई एम गोइंग टू स्टार्ट विद दिस पर्टिकुलर टॉपिक टुडे एंड फर्स्ट set of important questions I am going to discuss in this video today. So the first question is, which of the following is not true about judicial intervention in arbitration proceedings? Extent of judicial intervention is covered under section 5 of the act. No judicial authority may intervene except as provided under part 1. No judicial authority may intervene in arbitration proceedings in any case. If provided expressly in part 1, judicial authority may intervene in arbitration proceedings. Both C and D. So इसमें से आपको ये देखना है not true क्या है. Okay, many students, what happens when they read the question and the options in one go, they get confused because they don't read this not. So ये गलती आप मत कीजिएगा अगर आपने ये अभी की है तो. Which of the following is not true about judicial intervention? That is, in what case judicial intervention can be done that has been mentioned expressly in that. तो ये provision आपको पता होना चाहिए. It is a very important provision and also this is a debatable issue actually. इस पर काफ़ी सारा research भी आपको मिल जाएगा and ऐसे areas पर generally questions भी पूछे जाते हैं. So we should be clear with our concepts. So the correct answer over here is C. In any case, judicial intervention is not allowed. ऐसा नहीं हो सकता है. So this is a very absolute statement and it is a very negative statement. ऐसा कुछ भी नहीं है because section 5 guarantees extent of judicial intervention expressly provided in this part. Okay, so that is false. Second question. This is an interesting one. A communication through WhatsApp providing record of agreement to arbitration. You all know arbitration agreement. It is a very, very important topic from this act. So if you are making a WhatsApp communication, will not amount to an arbitration agreement, not amount to a valid arbitration agreement, amount to an arbitration agreement in writing, amount to an oral arbitration agreement, C or D, as per discretion of the arbitral tribunal. That means the arbitral tribunal will decide whether it would be treated as oral or in writing only. So this is a very interesting question and I would suggest you all to be prepared for such kind of questions also. कि आपको twist करके भी questions पूछे जा सकते हैं. So your concept should be really clear, at least for the very, very important topics. Arbitration agreement is a very important area. Answer is C. Amount to an arbitration agreement in writing. Section 7 covers this. Clause 4, if you will check it out, exchange of letters, telex, telegrams, other means of telecommunication, including communication through electronic means, which provides a record of agreement. तो यहाँ पे हमारा ऑप्शन सी करेक्ट हो जाता है एंड वी ऑल नो आर्बिट्रेशन अग्रीमेंट इज शैल बी इन राइटिंग, ऐसी रिक्वायरमेंट है सेक्शन 7 में. Rules relating to jurisdiction of an arbitral tribunal shall be made by Supreme Court, High Court, presiding arbitrator, arbitral tribunal itself, parties themselves. Now this also, if you know, you can solve these questions very easily. ऐसे questions भी बहुत पूछे जाते हैं. Correct answer is D. Arbitral tribunal will make the rules on its own. Section 16 provides this. Mandate of an arbitrator can be terminated if he is not able to perform his functions de facto, he is not able to perform his functions de jure, he withdraws from his office, parties agree to the termination of his mandate, all of the above. So the correct answer here is all of the above. We can very easily make it out even if we don't know this, but henceforth try to remember this. All these are the conditions in which the mandate of an arbitrator can be terminated. He's not able to perform his functions de facto, he's not able to perform his functions de jure, if he's withdrawing from the office, parties are agreeing to the termination of his mandate. And section 14 talks about this, failure or impossibility to act. ऐसा particular provision है हमारे पास which is covering all these conditions. Fifth question, in case parties adopt fast track procedure for arbitration, parties may agree to appoint a sole arbitrator. Court may, on an application made by parties, appoint sole arbitrator. Parties may agree for a sole arbitrator to be appointed by the High Court. Court shall suo motu appoint one arbitrator for the parties. There is no any specification as to appointment of arbitrator or arbitral tribunal. So, in case parties adopt fast track procedure for arbitration, in that case, which of the following will be correct? Correct option is B. Court may, on an application made by the parties, appoint sole arbitrator. Section 29B talks about fast track procedure, which says this. Fast track procedure, these are amended sections and everybody should know that. And I hope everybody is knowing all the important provisions. And section 29B is one of them. Interim measures can be ordered by an arbitral tribunal as per section 9, section 17, section 10, section 11, section 5. So interim measures can be ordered by an arbitral tribunal as per which section? अब ये directly section based question है, ऐसे भी questions पूछे जा सकते हैं. Interim measures can always be ordered by arbitral tribunal as well as court. ये भी एक बहुत ही important area है. I would recommend everybody to remember the sections also. So section 17 covers the interim measures that can be ordered by an arbitral tribunal. Correct answer is section 17. Which of the following is not an interim measure that can be ordered by court in case of arbitration? Appointment of a guardian for a minor or person of unsound mind for arbitral proceedings. Order to secure the amount in dispute in arbitration. Detention, preservation or inspection of any property or thing which is the subject matter of the dispute in arbitration. Order for settlement. None of the above. So which of the following is not an interim measure that can be ordered by court in case of arbitration? अब ये कोर्ट की बात हो रही है. सेक्शन 17 को यहाँ पे कंफ्यूज नहीं करना है. Which of the following is not an interim measure that can be ordered by court in case of arbitration? So कोर्ट की बात अगर हम कर रहे हैं तो that is section 9 which is covering that. And the correct answer over here is option D, because what they have asked you over here is which of the following is not an interim measure that can be ordered by court in case of arbitration. Which of the following is true about making of an arbitral award? It shall be made in writing. It shall be signed by the parties. It shall be signed by the parties. It shall be signed by members of arbitral tribunal. A and C. A, B and C, that is all of the above. So which of the following is true about making of an arbitral award? Arbitral award भी एक बहुत ही important area है. Answer is D, A and C, that is it shall be made in writing, it shall be signed by members of the arbitral tribunal. Section 31 talks about form and contents of arbitral award. An arbitral award shall be made in writing, shall be signed by the parties and by the members of the arbitral tribunal. It should be basically signed. That is very important. Conciliation में ये अब जब मैं questions डिस्कस करूँगी आपके साथ, तब I will tell you all these things that signing of the parties is very important over there. Okay, यहाँ पे it shall be signed by the members of the arbitral tribunal is important. Signed by the parties is not important over here. So the correct answer over here is D. When can a plea that arbitral tribunal does not have jurisdiction be raised? At any time before the arbitral award is passed, at any time after arbitral tribunal is constituted, at any time before the submission of statement of claim, at any time before the submission of statement of defense, at any time during the making of arbitral award, but not after that. So when can a plea that arbitral tribunal does not have jurisdiction be raised? The timing has been asked over here. So this is also a very deep question कि कब actually ये plea raise की जा सकती है. Correct option is D, at any time before the submission of statement of defense. Remember this, section 16 clause 2 covers this particular area. Statement of defense, not claim, okay? Defense. The last question for today's discussion, which of the following is not true about rules of procedure of an arbitral tribunal? Parties are free to determine. If parties fail to agree, arbitral tribunal may conduct proceedings in the manner as they think appropriate. Arbitral tribunal shall not be bound by the rules of CPC and Indian Evidence Act. Arbitral tribunal shall also have the power to determine the admissibility and weight of any evidence. Arbitral tribunal may, if it thinks appropriate on its own motion, determine the rules of procedure without waiting for the parties to determine. So what have they asked over here? Which of the following is not true? Okay, so not true has been asked. Please focus on that. What are the rules of procedure for arbitral tribunal? That should be clear with you. And the correct option over here is E. Tribunal may, if it thinks appropriate on its own motion, determine the rules of procedure without waiting for the parties to determine. ये option गलत है. Section 9 talks about the determination of rules of procedure. It is not bound by CPC, Indian Evidence Act. ये बराबर है. Parties are free to agree on the procedure to be followed by the tribunal. That is something which is parties can determine. Okay. And if suppose there is no agreement, then the tribunal may, subjected to the provisions of this part, conduct the proceedings in the manner it considers appropriate. And this power includes power to determine the admissibility, relevance, materiality and weight of any evidence. ये सारा power arbitral tribunal के पास होता है. So this was all that I had to discuss with you all from Arbitration and Conciliation Act set of first important questions. If you have any queries, you can write to us directly in the comment section of this video. And also if you require any questions or if you have any doubts, you can reach out to us on hello@iexambee.com, or else you can call on the number 9205524028. Don't forget to subscribe to LegalBee and prepare 50% faster with us at iExambee. Thank you everybody. Have a good day.